To learn more about earning college credits with study hall courses, go to gostudyhall.com or click the link in the description. There aren't a lot of jobs where, once you're hired, you plan to work there until you literally die, unless you're the Pope, but even they're normalizing late retirement nowadays. But for federal and Supreme Court justices with lifetime appointments, they can keep their jobs as long as they want. And the thing is, they're not actually voted in by the people. Federal and Supreme Court justices are nominated by the president and approved by the Senate, with no worries about re-election and their lifetime appointments. They're basically unfireable. So in that unlimited time on the bench, they're wielding incredible power as the ultimate arbiters of what the Constitution does and doesn't say. But they're only human, with biases and different ways of interpreting the law. That matters because they're meant to be unbiased in their judgments on things that include even the most private, personal topics like what we can and can't do with our bodies. Hi, I'm Dave Jorgensen, and this is Study Hall, Power and Politics in U.S. Government. There's no denying that the Constitution reflects the time it was written and the people who wrote it. There's no mention of same-sex marriage or abortion access because the founders probably couldn't imagine these things being controlled by the federal government. And to understand the power of the Supreme Court, where decisions are made about these kinds of issues, we need to get to know its justices. It's probably not a huge surprise, but it hasn't been super diverse. Of the 116 justices to ever serve, all but 8 have been white men. Most have been Protestant Christians, and all of them have been straight, as far as we know. But if we were to have a more diverse court, it would lead to more diverse perspectives and more just and impartial decisions. Groups of people with different backgrounds make better informed decisions on a wider array of topics, and having a diverse court increases public confidence in court decisions, since the people can see themselves represented in who's on the bench. Which brings us back to interpretation. It matters who's on the bench because it's up to justices to interpret our laws, including in landmark cases that involve the civil rights and liberties that we hold dear, but aren't always mentioned in the Constitution. These are the kinds of cases that decide who can vote, who can get married, and even what we're allowed to say. And so you might be wondering how there could be so much debate and uncertainty when it comes to interpreting the law. Well, the U.S. Constitution is the oldest written constitution still in use, and among the shortest of any major government in the world. It's so short, there's a lot that isn't explicitly stated, and that gives a lot more power and flexibility to the courts when it comes to interpreting the constitutionality of our laws. In addition to being a short king, the U.S. Constitution was written in general terms on purpose so that it could be adapted to future situations the founders couldn't anticipate when they were alive. But what that did is open the door to different ways of interpreting the same document. Some justices interpret cases more strictly, which means they take a very literal approach to what's written, while others interpret it loosely and treat the Constitution as more of a guideline, since our society has changed so much since the time it was written. And nowhere has the significance of interpretation been clearer than in cases related to the right to privacy, which is essentially the right to be left alone by the government. There are no explicit references to the right to privacy within the Constitution, which was written back when every doorbell wasn't a surveillance camera. But the Ninth Amendment says that not all rights are necessarily included in the Bill of Rights and that others exist. So when judges are deciding cases that relate to privacy, there are 2 main approaches they use to defend their stances. The first is called the penumbra doctrine, which gets its name from the shadowy area that's partially illuminated at the edge of an eclipse. Basically, rights that are supported using penumbras can be found in the gray area surrounding other parts of the Constitution. Justice William Douglas argued throughout his long career that the right to privacy was implicitly hidden in the shadows of the Bill of Rights. And no, that's not the plot of National Treasure 3. Specifically in parts of the First, Third, Fourth, and Fifth Amendments, like how in the Fourth, we're protected against unreasonable searches and seizures, so privacy is implied in that protection. The other way that judges have protected privacy relies on the 14th Amendment's Due Process Clause, because the right to privacy is also implicitly guaranteed, where it says that the government can't deny someone their life, liberty, or property. The penumbra doctrine was especially important in early cases around privacy, but in the 21st century, we've seen the 14th Amendment approach being applied more often. And despite their small differences, both approaches come from the 1965 case Griswold versus Connecticut. In that case, different justices thought that early penumbras, or the Due Process Clause, justified them striking down a state law that had prevented married couples from buying contraception. But even after the Griswold case, the issue of contraception wasn't totally settled. After all, it only gave the right to contraception to married couples, showing the incremental nature of how our laws change over time. Just 2 years later, in 1967, the issue of contraception came up again when reproductive rights activist Bill Baird handed out some contraceptive foam to a student after his lecture at Boston University. Baird started advocating for sexual health and abortion access when he was the clinical director of a birth control manufacturer in the 1960s. After witnessing a woman's death as the result of an unsafe abortion, he founded the Parents' Aid Society in 1963 and was eventually dubbed the father of the birth control and abortion rights movements. Baird went to jail 8 times across 5 states for giving lectures on contraceptive methods and abortion. In the Boston University example, it turned out that him handing out contraception went against Massachusetts' crimes against chastity law. Sounds more like something from the 1670s. Anyway, that's what ended up landing him in the middle of the 1972 Supreme Court case, Eisenstadt versus Baird. Baird argued that talking about contraception was protected by his First Amendment rights, and that the Massachusetts law infringed upon the fundamental rights of unmarried couples protected by the 14th Amendment. In the end, the court ruled 6-1 in his favor. While ignoring the free speech element completely, Justice William Brennan said that the ruling reinforced an individual's right to privacy when dealing with things like sex, pregnancy, and contraception, regardless of relationship status. The court argued that there's no rational reason to distinguish between married and unmarried people when it comes to accessing contraception. Eisenstadt was a landmark case because it provided a basis for the evolution of privacy rights through the late 1900s and into the 2000s, and it shows how the mostly men of the Supreme Court got their authority to rule on cases regarding reproductive health. Just 1 year later, in 1973, the Supreme Court pivoted from birth control to abortions, while still using the 14th Amendment to justify the right to privacy. In Roe v. Wade, the court ruled that a person's decision to have an abortion was protected by this implied right. But the Supreme Court wasn't finished talking about abortion after Roe, because incremental change. So in 1992, with Planned Parenthood versus Casey, more legal questions popped up. There were requirements of spousal notice, where the person giving the abortion had to first notify their spouse, and an essential waiting period, where the patient had to wait 24 hours between their initial appointment and their procedure. So in this case, the court came up with a test of undue burdens, which assessed whether these abortion laws violated the Constitution by creating unfair barriers for people trying to get the procedure. Only spousal notification was struck down, because for people in unsafe relationships, informing their partner might create an even more dangerous situation and place an unreasonable burden on the person seeking the abortion. But the waiting period in minors getting parental consent were still held up as of 1992. But the court's ruling that allowed all people, whether they were married or not, to get contraception in Eisenstadt versus Baird firmly established the foundations for privacy within the law. We see this precedent, or guiding legal example, of privacy being used in more recent cases. For example, in the 2003 case of Lawrence versus Texas, the Supreme Court heard arguments on laws that criminalized gay sex. You heard that right, in 2003. In Lawrence versus Texas, the court cited Eisenstadt in its rulings, saying the laws were unconstitutional because they violated an individual's implied right to privacy. And then, in the 2015 case of Obergefell versus Hodges, the court overturned same-sex marriage bans on due process grounds, making same-sex marriage legal across the country. The court argued that state bans of same-sex marriages were unconstitutional because the right to marry is implicitly guaranteed and applied to the states via the 14th Amendment. So, throughout the first 2 decades of the 2000s, privacy rights became even more common and more protected through the court's decisions, building on what was decided in the past. But the evolution of these rights hits a bit of a roadblock as of June 2022 with the court's most recent reversal of a legal precedent. In Dobbs versus Jackson Women's Health Organization, the Supreme Court reversed their original rulings in both Roe versus Wade and Planned Parenthood versus Casey on the basis that the Constitution doesn't mention abortions, nor does it implicitly protect these procedures. In forming the majority opinion or the official decision, the court argued that previous legal arguments using the Due Process Clause ignored the facts that any rights upheld by this clause must be embedded in U.S. history and tradition. And they said that abortion access isn't a right that's included within that category. The Dobbs ruling changed abortion from a federal issue to a state one, so that each state got the sole authority to regulate abortion. And so this one decision limited abortion access in about half the country as of 2023. But state laws are always changing. The aftermath of Dobbs leaves some wondering what this conservative-leaning court will do next. Other civil liberties like same-sex marriage, access to contraception, and interracial marriage could potentially be struck down using this same logic. So the court has a lot of power to reverse major decisions about the rights of people that were previously expanded by earlier courts. But we are on the Supreme Court, even though I have this robe, so we can't predict how they'll interpret the law in future cases. Many thought that Roe wouldn't be overturned because it was settled as a precedent of the Supreme Court, as Justice Kavanaugh said during his confirmation hearings in 2018. As history has shown, our civil rights are subject to change as the people in our legislatures and courts change, or even when those people change their minds. Legal precedents carry a certain weight, but these rulings aren't set in stone. Supreme Court justices have a lot of power when it comes to deciding the cases in front of them, and their decisions are often reflective of who is on the court at that time. But the Supreme Court was originally intended to be an apolitical institution and completely separate from politics. Lifetime appointments were meant to allow justices to make their decisions without worrying about their popularity, like they would if they were up for re-election. But the appointment process means that more liberal presidents nominate more liberal justices, and more conservative presidents appoint more conservative ones. So there's a clear motive for leaders to get people who are aligned with them into positions that allow them to make impactful decisions for decades, even after they've left office. And the US public seems to be catching on because as of 2022, 2/3 of people think there should be term limits or mandatory retirement ages, and the approval ratings for the Supreme Court continue to fall well below 50%. Part of that is because rulings like Dobbs have a major impact on millions of people, demonstrating the immense power of the Supreme Court. And who knew that some of that power comes from the words written between the lines of the Constitution, except for Benjamin Franklin Gates, who had magical glasses. If you're enjoying Study Hall Power in Politics and U.S. Government and are interested in taking an online course and earning college credit, check out gostudyhall.com or click on the button to learn more. Thanks for watching. See you next time.